Let me double check if that's okay. Ladies and gentlemen, we'll be starting in a few moments. We're still waiting on some of our speakers. We'll be starting momentarily. Thank you for your understanding and patience.
Yes, it's 82. It's 82.
I sent also this morning.
Those chairs are heavy.
And they don't have wheels, so it's very hard to move them.
That's exactly what I've been having as an issue.
Yeah?
Should we start at 35? Maybe kick the video and then we'll see what happens?
Yes, I think so.
Okay.
In last case,
Oh, wow.
is that Christina?
We have some good audience.
Yes, let's. Okay.
I think so. I think she just from that, so then we can start. Yeah, thank you. I think they turn it on over there. All right. Distinguished delegates, ladies and gentlemen, transformation, power, law, justice, transition, climate. If any of these words strike a chord with you, then you'll be very excited about this side event. If they do not, stay tuned, and I'm certain by the end of it, you'll have been converted. My name is Ayman Cherkaui. I'm the director of the Hassan II International Center for Environmental Training and deputy chair of the IUCN Work Commission of Environmental Law. I'll be your moderator for today's session entitled The Transformative Power of Law in Promoting a Just Transition to a Climate Positive word. This side event is organized by the University of Oslo and the International Development Law Organization in partnership with the International Union for the Conservation of Nature's World Commission on Environmental Law, Climate Change Law Specialist Group, and the United Nations Environment Programme. The session will be structured in 3 parts. First, we'll have opening remarks. Then we'll enjoy a panel discussion. As you can see, we have an amazing panel that is very excited about exchanging with you, and I hope you share in their excitement. We then will be enjoying concluding remarks at the end of this session. So, without further ado, we will kick off this session with the opening remarks, and we have a message from Jan Beagle, the Director General of IDLO. I'd like to ask the technical support team to launch the video. Thank you very much.
Development Law Organization. Good morning. On behalf of the International Development Law Organization, it is a pleasure to welcome you to this side event on the transformative power of law in promoting a just transition to a climate-positive world. I'm sorry not to be with you in person. I would like to thank our co-organizers, the Climate Change Law Specialist Group of the IUCN World Commission on Environmental Law, the University of Oslo, and the United Nations Environment Programme for their partnership, and above all, for their unwavering commitment to championing the rule of law and justice worldwide. When the Paris Agreement was first adopted in 2015, we knew that this COP would be a watershed moment, and arguably the first great test for this historic and vitally important treaty. Member parties and stakeholders had the chance to take stock of our collective progress and correct course to ensure that we are leaving a sustainable and livable planet for future generations. At this conference last year, Executive Secretary Simon Steele described the global stocktake process as an exercise in accountability. I would go a step further and say that it is also an exercise in justice. It has been made abundantly clear through both the global stocktake process and on the basis of the best available science that the climate crisis is not just an environmental crisis, it is also a human rights crisis. We know that the impacts are unjustly felt first and worst by those who have contributed the least to climate change. This is true both between countries and within every society. Adopting a rights-based approach to the climate action agenda through the rule of law is not only the right thing to do, it has unequivocally been shown to lead to better outcomes across environmental, social, and economic development indicators. And we urge those sitting around negotiating tables not far from here to acknowledge the importance of strengthening the rule of law in the outcomes of the global stocktake, to promote rule of law principles such as equality, inclusion, and non-discrimination as key principles underpinning a fair, just, and green transition, and to prioritize equal and effective access to justice through a well-financed loss and damage fund that integrates human rights-based and gender-responsive approaches. The law has the transformative power to be a critical enabler of climate action, while also driving benefits across all aspects of sustainable development and promoting peace and prosperity worldwide. IDLO is committed to feminist climate action. In societies with higher levels of gender equality, where women and girls are legally empowered and have the necessary resources to claim their environmental rights, data has shown that there are lower levels of carbon emissions, air pollution, and deforestation. Strengthening the rights and protections for Indigenous people, including the principle of free, prior, and conformed consent, can have a profound impact on the conservation, restoration, and sustainable use of biodiversity, and will be critical for enabling ecosystem-based adaptation. Governments should adopt a longer-term vision that embraces an intergenerational approach and adjust short-term greenhouse gas targets to preserve the rights of future generations. For 40 years, IDLO has championed the rule of law as a catalyst for peace and sustainable development. We work across the law and governance landscape, both top-down, with governments to reform laws and strengthen institutions, and bottom-up, with people to empower them to claim their rights and access justice. We're taking concrete action. We're working with partners to mainstream human rights considerations into climate laws and policies, including by providing capacity building and technical support to government agencies to strengthen legal frameworks for environmental protection. We are supporting specialized environmental and land courts to facilitate more effective dispute resolution on matters relating to natural resource management. We've undertaken comprehensive legal assessments that analyze the gender blind or gender discriminatory provisions in national climate, legal, and regulatory frameworks, and provide recommendations for their repeal or revision. And we're working with civil society organizations with the goal of empowering women and girls to participate in and lead climate action efforts. Today, our discussions will enable us to share evidence and insights on legal and rights-based approaches to the climate action agenda. I'm confident that working together in partnership, we can do justice to the Paris Agreement and ensure that no person or country is left behind.
Thank you. Thank you very much to the Director General for having shared this important message with us, a fair, just, and green transition. I'm sure we'll echo with our next two opening speakers that represent not only institutions that are critical to this fair, just, and green transition, but are also in themselves leaders in this field. So the next speaker for this opening remark session will be Madame Christine Adam, who's the Director and Principal Legal Advisor at the UNFCCC. If I may invite you to join us at the lectern, please. Thank you very much. Under your applause, please. Thank you.
Thank you. Distinguished speakers, guests, ladies and gentlemen. It's a pleasure to join you here today in this event on transformative power of law in promoting a just transition to a climate-positive world. I'm grateful for the opportunity to share with you, distinguished practitioners, some remarks on transformative power of law in climate change. But I would like to start by really expressing my sincere and warm thanks to the organizers of this important and very timely event. As we know, climate change is happening in front of our eyes, and it's the biggest threat humanity has ever seen, with a profound implication on all areas of life and eventually international peace and stability. The IPCC report published in March adds more clarity and details to a simple truth. We have to do more on climate change, and we have to do it now. But it's not too late. The IPCC also clearly demonstrates that it is possible to limit global warming to 1.5 degrees Celsius with rapid and deep emission reductions across all sectors of global economy. Over the last 30 years, a lot has been achieved to address climate change. Through Convention, the Kyoto Protocol, the Paris Agreement, the completion of the Paris Rulebook, and countless other decisions and mandates, the international community has set out a clear infrastructure for the global response to climate change. And now is the time to put this infrastructure to use and set out clear pathways to implement climate change action in the long term. Here in Dubai, we are witnessing the conclusion of the first global stocktake at COP28, where nations can regain momentum to scale up their efforts across all areas and get back on track in meeting the goals of the Paris Agreement. The stocktake is intended to inform the next round of climate action plans under the Paris Agreement to be put forward in 2025 and pave the way for accelerated action. However, the stocktake must be more than yet another synthesis report. Countries must use this moment to agree on concrete milestones that will take us to our 2030 targets. Ladies and gentlemen, we are at a crossroad. We are presented with an opportunity of a lifetime, and in the words of the UNFCCC Executive Secretary, it's the opportunity to course correct. So what's the transformative power of law in promoting a just transition? The UNFCCC process, including the UN climate change conferences, institutional arrangements, and bodies, mandates, and decisions are deeply rooted and evolved from the legal framework provided for in the Convention and its aggregate of multilateral agreements with nearly universal membership. And at the heart of all our discussions lies a normative process, which is different from political declarations. International instruments, such as the Paris Agreement, have the distinct advantage of producing legally binding obligations upon the signatories. Once agreed, the state party must deliver. The UNFCCC regime of agreements permeates, shapes, and inspires the legal response at the domestic level. Advances in the international arena transform environmental implementation, compliance, and enforcement. International legal instruments such as the Paris Agreement have motivated and informed an increase in national climate commitments, legislation, and jurisprudence. There has been a rapid expansion of national and subnational climate laws and regulations, and in addition, climate change litigation has grown exponentially in recent years. According to estimates by UNEP, that are also present here today, at least 2,396 climate change cases have been filed in 55 countries and international adjudicatory bodies as of July 23. And this brings me to my third point. In order for our legal framework to be effective, we need support from all stakeholders. We only have little time left to bend the curve on climate change, and there is no way out. Law is one of many means to address this crisis, but there are inherent risks and limits. We can negotiate legal texts, but as has been stated elsewhere earlier this week, we cannot negotiate with nature. To be clear, legal frameworks, such as the UNFCCC regime, can only be a starting point. It's not an end in itself, but serves to promote, guide, and support the work accomplished by its parties with the help of everybody else, like business, civil society, and many others. Therefore, more than ever, legal process needs to be conducted in consultation with others. The UNFCCC Secretariat is the guardian of the key multilateral process in which every country has an equal voice, where civil society can represent their views and defend their views, and where businesses can present their solutions. And lastly, climate action requires a truly inclusive and interdisciplinary approach by calling upon parties to respect, promote, and consider their respective obligations on human rights. The Paris Agreement integrated human rights into climate action. As we scale up our efforts, we must avoid mistakes of the past and must make sure that the most vulnerable are not left behind in the fight for climate change. Those most likely to be affected by negative consequences of climate change are already marginalized groups, including women, children, disabled, and indigenous communities. While the climate change process will require some radical changes in the system, these changes must be made equitably and just in order to protect the most vulnerable. Ladies and gentlemen, finally, as guardians of the climate change regime agreements, we at the Secretariat are stepping up to further support parties, hearing all voices to come together and achieve the commitments made. And I hope all of you will help us to do so. I wish you fruitful deliberations today, and I thank you very much.
Thank you. And I do believe that the hope that you shared will turn into a commitment by the end of this event, if it's not already the case. Thank you very much. Among your important elements, I jotted down, we can't negotiate with nature. In order to introduce our next speaker, Professor Patricia Mbote, who's the director of the Law Division at the United Nations Environment Programme. She's also a member of the steering committee of the IUCN Work Commission Environmental Law. She's joining us online. Dear Patricia, the floor is yours. Thank you.
Ayman, distinguished guests, delegates, honored representatives, esteemed partners, both in Dubai and those joining virtually like myself from around the world. As the director of the Law Division at the United Nations Environment Programme, it is an honor and privilege to speak at this side event on the transformative power of law in promoting a just transition to a climate-positive world. This event is indeed a testament to our confidence in the law as an important tool in climate action. As a lawyer by training and law professor who's trained thousands of lawyers, I am proud to witness their unwavering commitment to address the critical issue of climate change through legal frameworks and effective governance mechanisms. I would indeed really like to thank the organizers of the event for organizing it and getting the issue of law on the agenda, and also inviting UNEP to participate. The realization of climate action goals requires us to implement prompt, fundamental, and comprehensive transformations in environmental, social, and economic sectors worldwide. Transforming to low carbon and climate resilient societies and economies will alter existing societal structural settings. The transformation will have varying effects on different regions and social groups. To do this, we must ensure that economic and social benefits and protection of vulnerable populations are factored in, because they will be affected by decarbonization costs. And law must play the critical role that it promises in this space. Just transitions indeed require an inclusive approach, cognizant of justice and equity for collective resilience. Climate mitigation and adaptation solutions must be gender responsive and inclusive, engaging civil society, the private sector, local governments in collaboration with communities most affected. Law remains the platform for safeguarding this inclusiveness. UNEP's 2023 Environmental Rule of Law report makes it clear that climate change is a long-standing concern. Climate action has become the primary object of new laws. This report stresses the need for inclusion of vulnerable societies in climate action. And a rights-based approach is evident in the lawsuits and judicial decisions that have come up relating to climate change. Just transition laws require us to leave no one behind. We must emphasize the participation of marginalized groups in all stages of climate action, from policy development to enactment of laws and subsequent implementation. We must also ensure that the burdens that arise from decarbonization are equitably shared. Rights are widely recognized as a powerful tool for realigning national and international priorities. Environmental rights can emphasize environmental issues and provide means of redress to vulnerable populations, including indigenous peoples. Adopting a rights-based approach to decarbonization allows engagement of all people, while effectively balancing the diverse needs and interests of communities, particularly the most vulnerable. This approach ensures inclusivity and fairness, prioritizing the involvement and well-being of all individuals throughout the transition. Climate litigation grounded on human rights, as I pointed out, has emerged as an important avenue for addressing climate change and a just transition. The 2023 UNEP Global Climate Litigation Report found just transition cases are gaining momentum. Just transition cases, quote, question the way in which climate policies are developed and implemented or impact the enjoyment of human rights. In this process, decarbonization burdens can be adjusted. The climate litigation report further notes that it is likely that just transition cases brought by workers and communities in vulnerable situations impacted by these policies will lead to lawsuits questioning potential breaches of their human rights. These cases often center around participation of impacted communities in government decisions. At UNEP, we recognize that law is a powerful and transformative tool in shaping global responses to the climate crisis. Law provides a basis to allow all persons' needs to be taken into account in the decarbonization process. It is within this context that the Law Division has tirelessly worked to advance environmental governance, promote environmental rule of law, and support countries in developing and implementing sound legal frameworks for environmental protection. Through our 5th Montevideo Environmental Law Program, we support the development and implementation of environmental rule of law, and we strengthen the related capacities in countries and the environmental dimension of the 2030 Agenda for Sustainable Development. Our objective is to advance the environmental rule of law by empowering countries to develop and implement comprehensive legal and institutional frameworks, which of course will then benefit their citizenry. Climate action is one of our key priority areas under the Montevideo program, and this year we convened regional stakeholder consultations to better frame the substantive focus of this priority area. What is clear, however, is that law lies at the heart of a just transition and our work at the Law Division. And this is why we consider the discussion today very critical to our work. The insights, knowledge, and collaborative spirit that each one of you brings to this forum will undoubtedly pave the way for innovative solutions and actionable strategies in using the law for climate action. As we embark on this discussion, I urge us to engage, collaborate, and contribute our expertise, insights, and passion towards forging a collective path that ensures we safeguard a clean, healthy, and sustainable environment through a fair and inclusive process that leaves no one behind. Let us embark on the journey together, driven by purpose and the shared determination to make a positive difference in the fight against climate change. I thank you and wish all of us a fruitful deliberation.
We thank you very much, Patricia, for these very insightful remarks, and can certainly attest to the tireless work of the Law Division that you lead. Thank you very much for being with us today. We'll now move to the panel discussion. I'll be introducing each of the panelists as I ask them a question. And the first one will be the one right next to me, Emina Pacho, who's a climate justice specialist with IDLO. And as I just learned, IDLO turned 40 this year. That'll be the case for me next year. With your permission, as I've always wanted to get into hip-hop, if I ever do realize that dream, could I refer to myself as IDLO -1? So more seriously, my question to you would be, IDLO has advocated for rule of law and human rights-based approaches to be centered in the global stocktake. From your experience, how has applying a justice lens to the climate action agenda promoted fairer and better outcomes?
Thank you so much. Good morning, ladies and gentlemen. It's a pleasure to be here and speak on behalf of IDLO, the co-host of this side event. And yes, as our Director General, Jan Beagle, indicated in her opening remarks, for the past 40 years, our mission at IDLO has focused on advancing the rule of law to drive peace and sustainable development. As regards regarding the climate change, we believe that climate crisis is fundamentally a crisis of justice that exacerbates inequalities and threatens human rights, especially of those frontline communities who suffer most from climate shocks. Therefore, climate justice is a central part of our work, and we believe that justice and human rights-based approach must be part of the solution in order to ensure that the responses to climate change as we already have heard from distinguished speakers in their opening remarks, that these responses are inclusive, equitable, effective, that they take into consideration diverse intersectioning vulnerabilities of those frontline communities, as well as they preserve the rights of future generations. We are currently at the moment of the first global stocktake process, which is not only, as our Director General indicated, is not only an exercise of accountability, but it's an exercise of justice. And in this pivotal moment, it is critical to look at how we can increase recognition of law as part of the global stocktake process, and also as part of the solution to deliver on the climate justice promise. At IDLO, through our integrated approach, including research, policy advocacy, and programming around the globe, we have tested several approaches to accelerate climate justice through the rule of law and human rights-based approach. And 3 elements has emerged to us as key, as pathways to just transition to a climate-positive world. And these are the following. First, we need to strengthen laws, regulations, and institutional capacity of justice systems and judiciary for climate-resilient development. We also need to empower the most climate-vulnerable people so that they can realize their environmental laws and also participate actively in decision-making processes. We also need to improve governance over land, water, and other natural resources to reduce climate insecurity. And initiatives based on those approaches, as our experience shows, have proven to be transformative. They have this transformative power, and they can deliver game-changing outcomes both for the people and the planet. And I would like to dive deeper right now into each of them. So the first one, the first pathway to climate justice, as we see it, is that climate justice requires fair, equitable, and effective regulatory frameworks to accelerate action and to ensure that climate policies place the most vulnerable people, the most climate vulnerable people, the frontline communities, at the forefront of the climate agenda. And here I would like to refer to an example of IDLO's work. So in Kenya, for instance, we focused on reforming laws. The Article 42 of the Kenyan Constitution recognizes the right to clean and healthy environment. So this means that the state must ensure the sustainable and equitable use of natural resources to protect biodiversity. So in order to ensure a proper implementation of this provision, IDLO has provided technical support to develop national legislation, which happened to be the first framework law on climate change in Africa. And I'm referring here to the Forestry Conservation Management Act and 2016 Climate Change Act. However, IDLO is now taking this work further, and we are working on developing climate change and forestry policies and laws at the county level, so at the local level, to make sure that the policies and laws they reflect and respond to problems and needs of local communities, on those frontline communities whose voices could otherwise be not heard. Also, I think speaking about laws and regulations in the context of the global stocktake, we also need to continue discussions of on loss and damage and how to operationalize it. So the fund needs to be inclusive. It needs to ensure inclusive participation on the frontline communities and all those most affected by climate change in decision-making on how these funds are distributed in order to ensure that they have access to justice. And also the fund needs to be rooted in human rights, reflect all the intersectional vulnerabilities that are caused and exacerbated by climate, and also be gender transformative. And all this has to go hand in hand with a strong, well-trained judiciary who has the power to optimize the benefits of mitigation and adaptation initiatives. And judiciary also can ensure accountability, human rights, and as we heard yesterday here at COP during the high-level judicial panel discussion, judges can push history in the right direction. Moving to the second pathway to achieving climate justice. So we can achieve, the second pathway is through empowering the most climate vulnerable. At IDLO, we are proud to champion feminist climate action. We strongly believe that only full and equal participation of women and girls in climate action can actually bring us closer to the goals of the Paris Agreement. As the recent IPCC report states, when societies have higher levels of gender equality, that translates into lower levels of deforestation, air pollution, and resource loss. So, for instance, at the moment, IDLO is implementing 2 pilot projects in Burkina Faso and Philippines, where we seek to reduce those barriers that prevent women and girls in active participation in climate action initiatives. And as part of this project, we are reviewing local laws and frameworks, regulatory frameworks related to climate. And we look how they impact and we look how those laws impact women and girls in the context of their land rights, access to justice, and gender-based violence. And this way we aim to eliminate the gender discriminatory provisions from the legal system. Additionally, within this project, we are also providing trainings to in both countries on gender-responsive laws and policies. And for example, in August in Burkina Faso, we provided trainings to our governmental partners, including also statistics departments, in order to promote this approach to collect gender disaggregated data so that we can build evidence that will be then included and well reflected in the next round of NDCs and will include women and girls' rights in all their diversities and their unique situation in the context of climate change. The third pathway to climate justice is through supporting effective governance and management of land, water, and other natural resources that is combined with justice systems, both formal and informal, that can help to resolve climate-related disputes and preserve the rights of future generations. This approach can also ensure that we respect the principle of free, prior, and informed consent for indigenous people and recognize their land rights that are often of customary, that include diverse customary land tenures systems and also might be of collective nature. And here, for example, in Somaliland, we have supported, in Somaliland, we focused on access to justice and we supported developing 6 alternative dispute resolution centers that aim to offer redress for in basic criminal and civil cases, also those that were generated by climate change and climate shocks. And this way, we wanted to ensure that traditionally marginalized groups, women, girls, youth, they have access, efficient access to justice, and in a broader perspective, that kind of can prevent rising of conflicts in the regionally. Similarly, in Rwanda, we have been supporting Abunzi committees who have also the role of being alternative dispute resolution mechanisms, especially focusing on land rights and resolving conflicts around land and of people who lost their property due to state policies. And just one last point, if I may, that refers to land. It's also, I would like to mention that food security and food systems transformation, and food systems should transform in a way that leverage indigenous people knowledge, improve ecosystem conservation and biodiversity preservation, and that respect the boundaries of our planet. I'll stop here. Thank you so much.
Thank you very much, and we could keep listening to you. Thank you very much, much appreciated. I'll now move to the next speakers, and I'm using that in the pro as be introducing them together, as I'll be asking to both of them the same question, and they are very much a team, a very winning team that's been very active here at COP in particular. Fabiano and Francesco are the co-chairs. Fabiano de Andrade Correa and Francesco Sindico are the co-chairs of the IUCN World Commission Environmental Law Climate Change Law Specialist Group. This specialist group provides legal and policy guidance to IUCN on the legal issues around climate change. With that in mind, and also acknowledging, again, the very active presence that you've had in this COP, putting together, for example, yesterday, a great event around islands pushing forward climate change law. And the Commission in general has been very active. I want to acknowledge also the presence among ourselves of Professor Simi Payne, who also has been very active and leads our ocean law specialist group. So with that in mind, how can law be used as an enabler of climate action in different contexts? And I'll be hearing your perspective in that regard, starting with Fabiano. Thank you.
Thank you very much, Ayman. Good morning, everyone. It's very exciting to be here, joining this panel with esteemed colleagues and such a good turn-up, despite being a legal event and almost the last day at COP. So it's really great to... Thank you for sharing this hour and a half with us. Before starting, I actually wanted to ask a question to you guys in the audience with us today. How many of you are non-lawyers? I'll be curious. Okay, it's a good number. And I asked this because getting into the question that I was asked, especially non-lawyers tend to look to the law as a hurdle, and to us lawyers as problem makers, as roadblockers. But I actually want to respond to the question by speaking to the role of law and to the role of lawyers as enablers of helping make things happen, which is what we really need in this COP and to face the climate crisis. And I want to do so by addressing an issue that fortunately has been increasingly recognized, which is the need to address these crises that we face, the climate crisis, but also biodiversity and ecosystem loss and pollution in a more integrated way. And to, of course, then find ways of building bridges across the regimes of international law that address these issues. And to do that, I'll turn to the concept of nature-based solutions. The concept of nature-based solutions is instrumental in this regard. For those that are not familiar with this concept, it is defined as actions to protect, sustainably manage and restore natural and modified ecosystems in ways that address societal challenges effectively and adaptively, and provide both human well-being and biodiversity benefits. So really an effort to bring more integrated approaches to these various crises. And coming to the context, of course, of the COP, alongside decarbonization, of course, nature-based solutions have become increasingly recognized as a key strategy to support climate change mitigation and adaptation while also providing benefits for people and the planet. And legal and institutional frameworks from global all the way through national levels play a key role in effectively enabling the design and implementation of nature-based solutions. At international level, there is, of course, as with any other policy concept, a need to provide a level playing field that sets common understanding, standards, and coordination among stakeholders and decision makers. The IUCN, with Francesco, I have the pleasure and the honor of being the co-chair of the Climate Change Law Specialist Group of the World Commission on Environmental Law, which is a specialized commission of IUCN. And IUCN has played a key role with regards to nature-based solutions, from crafting this definition that I read to you, to the development of a global standard on nature-based solutions that was released in 2020, that really helps decision makers and those implementing actions in the ground with 8 criteria and respective indicators. So really in an attempt to achieve this common understanding and give us a common framework to work with. We have also been seeing at international level some milestones over the past years. Last year, at the United Nations Environment Assembly, the UNEP, a resolution was issued recognizing the role of nature-based solutions for climate action. And this has also been included in last year's COP at Sharm el-Sheikh in the cover decision. So there's a lot going on, basically, at international level. But of course, the crack is then how to translate this into concrete action at national levels. And if not for anything else, research now shows that 2/3 of the NDCs to the Paris Agreement include NBS as a climate strategy for both adaptation and or mitigation. But then there's really a need, as I said, to understand how this becomes concrete action. And again, legal and institutional frameworks have a key role to play to enable that, to enable the implementation of NBS measures and actions from design to monitoring and implementation. And I'll mention 4 points, and I'll be brief because I know the time runs fast. But just as internationally, rules, policies, and standards at national level play a key role in providing a shared understanding and direction for defining and implementing nature-based solutions. And we see countries already starting to issue policies in this regard. I still haven't seen a specific law addressing it, but certainly some policy documents that provide a guide, a common vision and understanding. Secondly, legal responses to nature-based solutions need to be informed by best available science. They need to take a preventative and, where applicable, a precautionary approach. They need to safeguard against regression from environmental and social levels of protection. They need to ensure access to information, public participation, and access to justice in the design and implementation of these measures. And here, rules and legal principles also have an important role to play. Thirdly, relevant areas of law have a strong role in rolling out nature-based solutions initiatives. And I'll name just a few. Of course, environmental and biodiversity protection laws, which are key in countries to provide standards and minimum levels of protection. But of course, land use management and tenure laws, including also spatial planning and zoning. Climate action laws, which often at a higher level define how climate action in the country is to be organized and implemented. Human rights, of course, which have been mentioned by many of the speakers here today. And further, considering the relationship between people and nature, laws and policies related to indigenous peoples and local communities also have a very strong role to play in issues such as tenure and tenure rights related to natural resources and customary laws of indigenous peoples and how those are then related and recognized and enforced by statutory regimes. And last but not least, legal frameworks can also create opportunities to advance investments using nature-based solutions by setting forth safeguards, guidelines, incentive mechanisms for the sustainable utilization of biodiversity and ecosystem services. And here I'll give an example that I think bring all the points above together, which are carbon markets and carbon credits. These are a very important tool in the Paris Agreement. They're also one of the most contentious issues of negotiations here at COPs. You might have been following negotiations on Articles 6.2 and 6.4, which are still not concluded. I believe they're still going on today. You might have heard also representatives of institutions such as the World Bank. The president of the World Bank has been speaking a lot of carbon markets and their potential as an instrument to bring debt-free climate finance into the countries, and we know that they are an important tool to help economies decarbonize while also providing for additionality of decarbonization measures. But and in the context of carbon market discussions and carbon credits, using nature-based solutions to generate credits is increasingly also discussed. But it's also, of course, also very sensitive because it relates to issues of tenure of land, to the definition of carbon rights as if included or separate from land rights, to the recognition of the role that people that live in those lands have and the respect of their rights in the whole process from design to implementation, to the distribution of benefits arising from those revenues. And last but not least, of course, providing standards that need to be respected in the development of those credits, including something that is not obvious to many, but the fact that climate change action and mitigation needs to be also nature positive. It should not go against biodiversity, for instance. If not, it should not really be called a nature-based solution. So with that, I will just close and give the word to Francesco by saying that the Climate Change Law Specialist Group is developing work in this area by providing more understanding on the legal aspects of nature-based solutions in coordination with the IUCN Secretariat and the ENACT partnership that was created last year at COP27 to catalyze action in this area. Thank you very much.
Thank you. Thank you very much. And after having heard from the fantastic Fabiano, let's hear from the fabulous Francesco.
So not only do we have the same initial letter, now we are also fabulous and fantastic. I love this. So, hope you can hear me well. Huge thanks to the organizers, to IDLO, to UNEP, to the University of Oslo for having us here. And I'm obviously delighted to be here on behalf of IUCN WCL. So as a reminder, this is about how can the law be used as an enabler of climate action in different contexts. Fabiano, in a fabulous way, talked about law in the context in particular of nature-based solutions. I want to bring in the litigation aspect. So litigation as an enabler of climate action in different contexts. But before, we need to do two caveats. One, let's all remind ourselves why we're even here and where we were 8 years ago. So in Paris, for many countries, the red line was the 1.5 degrees. 8 years later, the 1.5 becomes even more urgent. And I'll leave it to that. You all know why. We need rapid decarbonizations, urgent decarbonization. The second aspect is a different context. Yes, climate change is a global matter, but impacts can be felt differently. And even loss and damage is not something that some countries own and some countries don't. I was reminded the other day of loss and damage happening in Portugal, in California, in Maui. Loss and damage happens everywhere. So the context is also very important. With that in mind, law needs to provide clarity on state obligations to drive urgent action that takes into account specific contexts. So clarity, urgency, and context. I'll say a few more words about each one of these 3 points. First, as you all know, there's a flurry of advisory opinions before international courts. ICJ, ITLOS, Inter-American Court of Human Rights, within the European context, European Court of Human Rights. The combination of all of this has the potential to add to much needed clarity of rules applicable to states, but indirectly also to private actors. And that's a very important promise of these advisory opinions. Second point, about urgency. The combination of international and domestic litigation has the potential to drive much needed urgent climate action by highlighting the risks, if you want to speak private sector, liability of parts of the private sector. When it comes to my third aspect, the combination of international and domestic litigation responds or has to respond to the specific context of states who may be particularly vulnerable to climate change. So if you look at the question of the ICJ, for example, there's a specific reference to SIDS and other particularly vulnerable countries. But also, and let's move to the domestic sector now, to private sectors that can be considered vulnerable to climate action, for example, in terms of job losses, And there's now a lot of talk about just transition litigation, for example. So, to conclude, law is an enabler for clearer international and national rules that will push urgent climate action that takes duly into account specific contexts. IUCN is part of this process through the work that we do in all of our programs, but in particular through the work of the World Commission on Environmental Law. And as WCL, we are indeed honored to have been authorized to take part of the ICJ proceedings. So let me leave you with one final thought. When it comes to climate action, the devil often lies in the detail. And I hope that by the end of this talk, especially for the non-lawyers in the room, you will see the role of law as the one providing the details and not the devil. Thank you very much.
Thank you very much. Still very much within the family of the IUCN World Commission on Environmental Law. Very happy to have with us Professor Nilofer Oral, who's a member of the United Nations International Law Commission and co-chair of the study group on sea level rise in relation to international law, and also a member of the steering committee of the IUCN World Commission on Environmental Law. Nilofer, the floor is yours. Thank you.
Thank you so much, dear Ayman, and thank you so much for the invitation by all the organizers, but particularly the co-chairs of the specialist group on climate change. And it goes without question that the WCL is very dear to my heart, so I'm really thrilled to be part of this panel and always to be part of the very important work that WCL does. So it's a wonderful topic, the transformative power of law. And I'm so happy to come after both Fabiano and Francesco, because unfortunately we need to remove this negativity that is associated to law. You know, it's terrible. And yes, law is an enabler. I fully agree with that, and law can be, and in fact is absolutely the critical tool for bringing about transformational change, particularly when we're looking at a multifaceted threat such as climate change. It impacts so many areas of law. So science is important, absolutely, we need the science. But without law, what are you going to do with the science? How are you going to transform behavior, and in particularly behavior of states? States are the ultimate drivers of change. And if we don't have the laws that are built on this science, states will not take that transformative change. And right now we need good law to bring about that transformational change, urgent, as you said, and even the 1.5 may not be enough, but if we could just get to that, that would be transformational itself. So I'm going to be talking today about the IDLO's opinion, advisory opinion, and what basically its importance to bringing about the transformational aspect. So my area is ocean law, and the reality is that the ocean has been on the margins of climate change for a long time, and yet it is the largest sink and reservoir for carbon dioxide. It has absorbed well over 90% of the excess carbon. It is absolutely critical to the climate system we have, and yet for some reason it's been on the margins. It's, I mean, it's in the Paris Agreement, it's in UNFCCC, but really in the limited function, what I call a functional role as a sink. On the other hand, we have this fantastic ocean constitution for the ocean, the United Nations Convention for the Law of the Sea. The problem is that it was negotiated and adopted before climate change was an issue. Yet, when we look at particularly Part 12, which is devoted, it's the first ever, and it still remains the most comprehensive legally binding instrument that addresses protection and preservation of the marine environment. It has fantastic provisions in it. The question, though, is, does it apply to climate change? And this was really not clear. And it is so critical, and not everyone here may be an ocean expert, but just to make it clear, what are the threats from climate change to the ocean? Ocean warming. Ocean warming produces multiple consequences, from the impact on marine life, ecosystems, coral reefs, including also our temperatures, extreme weather conditions. We also see sea level rise, and that's an area that we're working on that is impacting millions of people and communities around the world. Ocean acidification, because of all the carbon that the ocean has been absorbing, if you can believe it. For the first time in 300 million years, this is the science, we've actually managed to change the pH balance because of human activities. Fisheries, they're being impacted either from their ability to survive, or they're migrating north to cooler waters. And this, again, not only on marine life, but it has impact on the livelihoods of millions of people. But the legal framework for the protection of the oceans, as I said, wasn't clear. How does it apply to climate change? Is it greenhouse gas pollution, for example? So in December last year, the Commission on Small Island States was established, actually. Oh, no, it was established before. It was actually established in Glasgow, yeah, COP26. But in December, it brought the request for an advisory opinion before the International Tribunal for the Law of the Sea, exactly on these questions. What are the obligations of states to protect and preserve the marine environment from pollution, and in general as well? Now, advisory opinions, while not binding, they are authoritative statements. These are not merely recommendations. They have impact. And so what we're hoping is that out of this, the ITLO's advisory opinion will provide very clear statements of the obligations, because the Law of the Sea Convention has very clear provisions. Article 192, states have the obligation to protect and preserve the environment. I always say that there's really no other instrument with this level of clarity. And also other provisions, but in the interest of time, I won't go into detail. And may I say, there's also the definition of pollution that clearly is broad enough to include greenhouse gases. So we have a solid international convention with broad state membership, and what we need is an authoritative interpretation of that convention to see how it applies to climate change. Why is that important? And just following up on of what was said. Because once we have that authoritative statement, now the ball falls into states. Now they have the mandate, they have the guidance, they have the clarity, and hopefully the urgency as well, to adopt the necessary laws to bring about that transformational change. We need laws. They enable change. Without those laws, we will not be able to have that change. And so in the advisory opinion, the hearing took place in September. Many states, I think some 30 states and international organizations, including IUCN, participated. And it's very optimistic, very robust statements. I am optimistic that we will have a good opinion coming from the tribunal. And once that comes out, hopefully that will then translate into domestic action. And we talked about climate litigation. Why not have some climate litigation on the ocean? And this could really enable that as well, particularly as UNCLOS, the Law of the Sea Convention, is so clear on obligations to protect the marine environment, and now we make it clearer about climate change as well. So I'm a firm believer in the law, that it can bring about transformational change, and so thank you so much for this opportunity.
And thank you for your generosity in sharing those insights with us. Thank you very much. Our next speaker is Mert Kumru, who's the European Front Coordinator at World's Youth for Climate Justice. And as we were discussing right before the start of the panel, you told me that the high school you used to go to was 200 meters from the Peace Palace. I think there's some element of predestination right there. So my question to you would be, students and young people around the world have been the driving force behind the push for an advisory opinion from the International Court of Justice. What positions would you like member states and observers to adopt in their submissions to the court, and how can the court uphold the principle of intergenerational equity to ensure justice for young people and future generations? Thank you.
Thank you, Ayman, and thank you all for being here. Maybe it's good to start out by explaining exactly what an ICJ advisory opinion is. What is an advisory opinion? I know there's lawyers in the room, but not everybody is a lawyer. So let's go to the beginning. First of all, which court are we referring to? There's two international courts in The Hague. The one you referred to that's next to my old high school is indeed the more beautiful one, if you ask me. It's the Peace Palace. And at the International Court of Justice, the court we're talking about today, states come to basically solve legal problems that they have between each other. So it's state versus state, or state that brings an issue to the court. And exactly that is what we are doing here. It's difficult for individuals, it's actually impossible for individuals to bring up cases at the ICJ. Only states can do that. So young people from the Pacific 5 years ago had a class of international law. And they discussed with their professors, what is the final tool, what is the tool that we have within international law to seek climate justice? They came to the conclusion that this was the advisory opinion, a tool that the judges of the international court have. But the problem was they could not ask for one. They needed support of a member state. And that support came from Vanuatu. Vanuatu showed climate leadership by letting these young people take this important step to the court. So then we have this advisory opinion, right? Then the title of the tool itself already kind of explains a little bit what it does. It tries to provide advice on certain legal matters. Very famous advisory opinions are the ones on the legality of the use of nuclear weapons and the war in Palestine, for example. An advisory opinion is non-binding. This means that states do not have to abide by the ruling or by the advices from the court, by the judges. However, as soon as we have an advisory opinion, you could go to a national court and explain in front of this national judge that the highest court in the world, which we're all part of, there's no country that's not a part of the ICJ, has ruled on a certain topic. So basically, it's using a non-binding regime to have binding consequences. And what is then the question that we are asking the court? Well, the legal question was adopted by the United Nations this year in March. It was an historical event because for the first time ever, 132 member states voted in favor of the resolution asking for an advisory opinion from the ICJ on climate change. For your reference, there has never been an advisory opinion on climate change. There has never been a ruling by the court on climate change. So it's the first time in history. The second thing that was monumental was the fact that there were no votes against and zero abstention. No votes against. Obviously, there were abstentions, the usual suspects. I'm not going to point any fingers. But to give you an idea, it has been growing over the years. It was not only the Pacific Islands that are here to be representing themselves at the court. No, it's all of our states combined. It's good to know that nothing in our globalized world happens or occurs in a vacuum, especially not when we talk about conflicts and crises such as the climate crisis. A global problem requires the political and social context of the issue to be considered. And justice can only occur when injustice and unlawfulness are defined. And that's why we're asking the court to explain what the legal obligations are of states under the Paris Agreement. I would like to always make the following reference when I talk about the Paris Agreement. I see it as a paper tiger. It has a lot of possibilities and a lot of potential, but it does not actually provide for a pathway to achieve the 1.5 degrees that we desperately need. So the ideas are beautiful, but how do we get there? And that's exactly the question that we're asking the courts. Explain to states how they get there. provide them with the basis for the obligations that they have, that they should have, to prevent any emissions from happening, or to make sure that they will take actions in the future. So, yesterday in a side event, we were listening to the stories of young people from the Pacific. This was at the Blue Moana Pacific Pavilion. And this explains exactly what we actually want from the court. Young people from the Pacific emotionally shared their stories of their homelands, of their islands. They could pinpoint exactly where the water used to come 20 years ago and where the water and the waves come now. They need to pick up the bones of their ancestors, of their elders, that the earth is slowly uncovering due to climate change. So imagine, not even in their eternal final rest place do they find their rest due to the climate crisis. The land of their ancestors is no more. It's already gone. Their graves, their farms, everything is being swallowed by the ocean. The ocean giveth, but it also taketh. So it's all because this idea that we have, and that we still hear at this COP, in the final days, the final hours, the concept of this ever-growing consumption that we need to fill, this unstoppable need of growth. At the same time, we know that it drives, and we know what costs it brings. So, especially at which expenses are we willing to go to make sure that this takes on and keeps on going? So, it's very good to understand that when I talk about the violation of human rights, because that's also the nexus we're trying to achieve at the court, that the climate crisis is a human rights crisis, it is good to map out what kind of rights we're talking about. So for example, the rising sea levels, they threaten the lives of islanders in the Pacific Oceans in various ways. Tropical storms and floods deprive children of the right to education, for example. Schools are often closed for multiple weeks on end because you cannot go to your school anymore because your teacher is someone on another island that cannot reach you physically. The homes of people are being washed away. So your right to an adequate housing or the right to life is being threatened. And these are just examples of human rights that we have collectively agreed upon that are currently being threatened by the crisis. And then you hear last month, for example, that the Australian Prime Minister announced that they will grant the 12,000 Tuvaluans a right to live in Australia. Whoop-de-frickin-do. It's not helping anything. It's just putting a little Band-Aid on a massive open wound that is still currently taking place in the Pacific. There's no Pacific Brotherhood when you keep on drilling for fossil fuels while letting these people come to your homelands. Because they will be branded as refugees and they will always be seen as refugees. And let it be known, they don't want to leave their islands. They feel at home there. They don't want your fancy cities. They want their homelands. So I don't want to be alarmist or pessimistic or cynical. Actually, I'm the quite opposite. I always try to prevent my peers to fall in this surrounding of cynicism. And it's very difficult to not be a cynical person when you're walking around COP28. I mean, we see the pavilions of the OPEC. We see, I'm not even sure why they're here, but when you walk around, you see them trying to provide with an idea, a solution of a future in which they also play a role. Dear attendees, I'm trying to tell you, they have no role in the future that we want to form. Their role has been taking up too much space for the past decades. And in the limited time of my contribution here, I cannot go and I can never do the full justice of the complexity of the crisis or our fight for climate justice. But nevertheless, as a child of international law myself, I'm currently finishing up my master's in international law. I'm obliged to my profession to guard against the trend that encourages the contempt of our collective human rights. Because we all have the right to live. We all have the right to a safe home and livelihood. And the only message that should never be controversial is a message aimed at saving those human rights and at preventing unnecessary human suffering. We created the legal memorandum, a handbook, together with lawyers and international scholars from all kinds of fancy universities you've probably all heard of. And why did we do that? Because every country has the right to send in a submission to the court all of your countries have too. And we want to make sure that those countries include the arguments, the legal arguments that young people have formed and that young people want to be heard by the court. You can find this on our website as well. And what we do right now in our lobbying efforts is going to states directly to explain to them, we did your homework already, include it in your submissions at the court. But more importantly, we want young people to be present in those court walls. And I will go to my finishing remarks. I see that Ayman is... so what do we need from you? I want you to be going to your government officials, to the court itself. I want you to stand there at the court. The ICJ is a court by the people and for the people, and not despite the people. Claim every inch of that courtroom. Claim every second of speaking time. Because if they don't hear us now, they will never hear from some of us ever again. And that's the one thing that we cannot and we will not allow to happen. Thank you.
Thank you. Thank you. Thank you very much for this very important remarks. As we are behind schedule, we only have about 10 minutes for the Q&A part. And as we'll be collecting some questions or comments from the floor, I would like to invite you to be as succinct as possible so that we can have as many of them as possible. And then I will refer back to the panel so that they may answer to the questions and also seize the opportunity to make some short concluding statement. I can see already. Yes, please. Thank you very much for the support. Yeah, go ahead. Thank you.
Hello. Thank you so much for your presentation. My name is Marianaya. I'm a PhD candidate at Cornell Law School. And I have two questions. The first one is, you know, in this scope we are talking a lot about human-based, you know, climate action. And it seems like most climate litigation are not human-based or doesn't necessarily include human rights, for example, in the United States and in other common law countries. So my question is an open question for you all, is where you see any kind of added value in rights-based climate litigations versus just climate litigation based on torts, for example. And my second question is for Francesco specifically. He said that climate litigation also provides clarity. However, having three different advisory opinions requests before three different tribunals could also mean that some, like an advisory opinion could be progressive, another cannot be that progressive. So maybe, I don't know if clarity would be at odds at some point. Thank you.
Thank you. I see Lara and Talsa. Maybe two more or three, and we'll be closing there. 1, 2, and 3 in the back. Thank you.
Hi team, thanks so much for that. I'll be quick, and this is for Mart, and what a useful handbook. In knocking down every state party's door to say, are you submitting an opinion? I'm wondering, are you also knocking down their bar associations for their lawyers? Bar associations often provide submissions to the government domestically for proposed legislation and law. And I know of at least 2 countries that are deciding whether or not to put an opinion in, and it's via their bar association. Bar associations have young lawyer committees where that might be an avenue. So I ask, are you considering that? And if not, what, you've got about 6 weeks? And I would hope that you take that up, and I'd love to chat to you after. Thanks.
Thank you for this panel. I'm Talsa
No, Talsa, go ahead, and then.
Okay. I'm Talsa Mekaush from CASDL. My question is for the IDLO representative. IDLO works all over the world, including in conflict-stricken areas, and I'm wondering how is your work received among communities that are asking, especially around climate change, that are asking for basic rule of law when there isn't any, and if you see synergies between climate action laws and conflict-related laws or basic reestablishment of rule of law. Thank you.
Thank you. And the last question will be from the back. Thank you.
Hello, everyone. My question refers to the role of science in transformation of international law, current and future trends. To what extent best available science should inform international law obligations and national law obligations? Are we talking about using best available science, the new international obligations, or is just information for national policies?
Thank you. If you could introduce yourself as well.
Alexandra from International and Comparative Law Research Center.
Thank you. Thank you very much. So you each have 1 minute, and no more than 1 minute, so good luck to you. And I'll start right here, please. Thank you.
Thank you so much. So I'll start with the question directly directed to me. So I only have 1 minute, but I just wanted to flag that IDLO is working, yes, around the globe, also in the countries in conflict or post-conflict areas. And I think our rule of law approach is, our framework to approach rule of law is designed in a way that we would like to, as I mentioned, that we work with institutions to restore rule of law and to strengthen it in general, but also in the context of climate change. We work with customary and informal justice systems to develop them, like in this case, like in Somaliland, just to prevent conflict. So I guess through the rule of law general approach in the context of climate change, we can achieve the long-term results that we are seeking. Thank you.
Thank you very much. You were right on time. Fabiano, follow that leadership.
I'll make a very brief point about the role that I see for these advisory opinions, and I really think we are at a key point where the Paris Agreement and the obligations that it entails need to be clarified and spelled out very clearly. We know that we live through turbulent political times where political constituencies in many countries, including mine, have been trying to undermine the importance of the fight against climate change, but also what the Paris Agreement is and what it is not. And besides working as a legal professional, I also teach sometimes at courses at universities. And I hear so many times the idea that the Paris Agreement is soft law or has only voluntary obligations, and this is very far from the truth. So with the advisory opinion, my real hope is that this will be cemented by the court and that it will be clearly spelled out that the Paris Agreement, despite working primarily through the cycles of the NDCs, has actually very concrete obligations for countries to show high ambition and a progression of levels of climate action. So that is my real hope, and I think Francesco will speak in more detail about that.
Thank you. Please do, Francesco. But still, maybe more detail, but still 1 minute.
I actually want to answer more the question on the human rights. So I think human rights litigation actually over the past years has been risen. So if you look at the numbers as well, and even in the US, if I'm not mistaken, the state of Montana has had an amazing human rights case recently adopted. So I do think it's on the rise, actually. When it comes to lack of clarity, you have all different courts saying slightly different things. Well, that's what lawyers do. I mean, that's how law is, even in national settings. I think that's where legal interpretation comes in. And also, I mean, I didn't mention it, obviously litigation, let's not hope that, but it can also go wrong. I mean, look at the UK, you know, that there have been domestic litigation against the government and the government says, no, it's not going to work out. So litigation doesn't always go down your way from what you're asking for. But what we do know is that even when it does go wrong because of doctrinal separation of powers or whatever, it can have an indirect impact in terms of raising awareness and mobilizing climate action. So I do still think there will be a role for it.
Impressive, 59 seconds. Please go ahead.
So I will answer the question on science, and I think it was directed to me. It's very important. I think that if you look at the advisory opinion that came before ITLOS, particularly in the COSIS statements and hearing, science was absolutely central to it, and the best available science, of course. So very important. And I think when we're talking about climate change and environmental issues, you need to have science. But what's important is that best available science needs to be translated into a framework that can be implemented and acted upon through measures, and law is one of those very important tools. But absolutely, this is a time where we need to integrate science, law, and policy much more. Did I make it?
Yeah, you're actually the best one so far. Mert.
Here we go. Thank you so much for this amazing question, and a very valid, good one. When we talk about bar associations, we always also ask our countries that we go lobby to, basically, how they create those submissions to the court. Often they tell us that they are either uninformed or unaware how the ICJ processes work. So a lot of states never actually submitted to the court. And that's why we work together with lawyers from certain bar organizations to create this. However, our current lobby strategy does not include directly going to those bar associations. So this is actually very helpful. And I would love to also talk to you about this afterwards. But this is also an open invitation to everybody. If you have a country where you think is willing enough, join us and let us work together to make sure that we can make those submissions as progressive as possible. Thank you. Ayman, tell me.
Yeah, also, very well done. I mean, amazing. I don't know, I would not have been able to do that. I have to admit, in full transparency. What I can do, however, at this stage is invite my dear friend, Professor Christina Voigt from the University of Oslo, who's also the chair of the IUCN World Commission on Environmental Law and the co-chair of the Paris Agreement Implementation and Compliance Committee, who's been listening very intently, taking a lot of notes for concluding remarks here at the lecture, please. Thank you. Under your applause, please. Thank you very much.
Well, thank you so much. Many things, but I'll start with things first, because this is actually a first. This is the first ever side event organized by the University of Oslo School of Law, and it's a great privilege to do that together with wonderful partners like the IDLO, UNEP, the United Nations Framework Convention on Climate Change Secretariat, and of course the IUCN World Commission on Environmental Law, which is my other hat here. But thank you so much for partnering with us here in this event. The second thanks goes, of course, to the fantastic speakers we had here on this panel. I was listening very intensively, and I was struck by the complementarity of the interventions and the scope that you presented to us on the role of that law plays in that transformation that is upon us. And the third thanks, of course, goes to the audience. As you said, Fabiano, it is the second, or almost the last day of the COP. It's a legal side event, but it's an amazing turnout of you all coming here today. I'd like to say a couple of words about the background of the event. The terms that we chose in the title, and we had quite a bit of a deliberation of what to call it, but the terms transformation, just transition, 1.5 degrees, net zero, climate positive world, these terms have been around for quite some time. Many of them are in the Paris Agreement, and they have become kind of a standard currency that is being played with here at these COPs, and maybe in particular at this COP where the global stocktake is so central. But it is also maybe just now that we start grasping what they actually mean if we put them all together, if we look at them in conjunction, if we look at what does it mean to bring about a just transition to a world that holds warming to 1.5 degrees centigrade, and that leaves no one behind. That becomes a very complex challenge, which requires system-wide transformative changes of all sectors in this decade. And these are not just changes, these are unprecedented changes. We really have to step back and let that sink in. Unprecedented changes in scope, in scale, and in speed, which means that we are up to something so profoundly different that has never been done before. Never been done before. And that has to be done very quickly and in a way that is just and fair and takes account of differences in contribution and vulnerabilities and capabilities. An enormous task, in other words. And in that task, of course, as we heard throughout the panel, the law is absolutely central. It is the core tool to bring these changes about, to enable these changes, as many, if not all, interveners said. Yes, civil action is important. Yes, the market is important. But I don't think we can rely on the market to bring about all these changes necessary if the law is not in the picture. The law is necessary to present the framework around economic actors, to guide civic action, to protect civic action, and to do so much more. We need governmental intervention, we need the right laws and acts, we need changes to existing laws where they hamper the changes that we need to see, and we need effective implementation and enforcement, and of course we need an enlightened and independent and strong judiciary on the national level as well as on the international level. We've heard about the Paris Agreement. It is absolutely very crucial in that global fight against climate change because it addresses a collective action problem in a manner that is fair and just and balanced, but it's also important to understand it, to understand its provisions, to understand its iterative regulatory processes that are designed to push parties to the highest level of ambition. In the NDC communication every 5 years, the biennial reports, the global stocktake, which only took place for the first time, but is supposed to take place every 5 years. But the Paris Agreement cannot provide all answers. It's not a 42 agreement, in the words of Douglas Adams. We need other international law to complement the Paris Agreement. We need the law of the sea, and we heard Nilufer Oral talking about the advisory opinion from IDLO, the International Tribunal of the Law of the Sea, trying to understand how the United Nations Convention on the Law of the Sea functions in the context of climate change. We need human rights, and IUCN WCL is also involved or has been invited to provide a statement to the proceedings at the Inter-American Court in Human Rights, which is due in about 5 days from now or something like this. And of course, the International Court of Justice. But we also need trade law, we need trade and investment law, we need investment protection to function in the right way to help to bring this transformation about and not to hamper it and to prevent it. Lawyers have a huge possibility and a huge opportunity in this transformation, but they also have a responsibility. They have a responsibility to apply their abilities, their expertise, in a way that enables that transformation to a climate-positive world. And in this context, please join me in a round of applause for our wonderful speakers and our wonderful chair.
Well, this concludes our event. Thank you very much, and thank you also to the technical team for the amazing support. Thank you.